So let me start by introducing, to my right, your left, Blanca Rodriguez-Galindo, who is the Deputy Director, Head of Unit for Consumer and Marketing Law in DG Just at the European Commission. Next, we have Léon Mölenberg, who is a Senior Policy Advisor on Consumer Contract Law and Privacy and Data Protection for Ecommerce Europe, as well as for the Dutch e-commerce association, Rethinking.org. We have René Repasi MEP for S&D, also Professor of Law at Erasmus University in Rotterdam and sits on the IMCO committee. And, well, we've already heard from Florencia and Hans, so thank you very much for being back with us. Blanca, let me ask you, first of all, you heard the presentations there. What do you think about this new sort of concept of digital asymmetry and permanent vulnerability? It's seen as a less of a transitional thing and more that this seems to be a new normal. And do you agree that we need to take this into account as we recommend sort of policy changes or proposals to respond to digital asymmetry?
Well, first of all, good morning to everyone. I hope this is working. Please let me know if you cannot hear me well. Thank you very much, Jennifer, for the question. Thank you to BEUC for organizing this event and for counting with the European Commission and the service responsible for consumer law once again. We definitely like the concept of digital asymmetry. And Professor Micklitz was saying before, maybe the European Commission can find another more fancy concept or fancy words. I don't know. But what we like about it is that it's a sort of umbrella concept which integrates all the problems, the problems to which consumers are confronted, all the concerns to which consumers are confronted in these digital markets, this type of structural asymmetries. And you have heard that already today several times from the two professors, also from Vice President Vestager, that the Commission is right now engaged in a digital fitness check process. And what is digital fairness precisely? The digital fairness, it's about addressing this, trying to rebalance this digital asymmetry, trying to define better which are the practices which are fair or unfair, legal or illegal in this digital market, to give better parameters to traders to comply with the law, and give a better legal basis also to consumers to to enforce their rights. So the short answer to your question is yes. We need to tackle this notion of digital asymmetry. The question is on the how, and that was digital fairness exercise in which we are working now is about. First, we need to evaluate the rules that we have already. We have heard also this morning from some that they are not sufficient, but for us as European Commission, we need to prove that. We need the evidence, we need the thorough assessment of them. And then, if confirmed that indeed the rules are not fit for this purpose, what do we need to do in terms of new rules, modification of the existing rules? So let's look, always talking about the concept of digital asymmetry, what we have right now. We have a concept of a vulnerable consumer. A vulnerable consumer, but it's true, it was thought to address problems related to disabilities, mental, psychological disabilities, where now we are confronted to a different type of situation. Someone said this morning, Florence, but also Vice President Vestager said, the most weakness is all now. That concept of weaker consumer, it's more extended now. It's almost every one of us, including very well-informed consumers that we should be when we are confronted to all the practices in digital markets. But so far what we have said also, this concept of vulnerable consumers, which exists already, which is in the law, we consider that a dynamic concept that not only addresses situations of disabilities, as I said before, it addresses also the financial situation of a consumer which is in unemployment, the problems related to gambling, for example, these type of things. But also the more structural problems, the more structural issues which rise from this digital-driven, data-driven economy. So we consider we have also issued guidelines explaining how we interpret in this broad way, this dynamic way, and even situational way, this concept of vulnerable consumer. But possibly more is necessary. We need to develop in law what digital asymmetry means. I'm not yet answering the question, I'm putting the question to which we are reflecting. But beyond the general concept of what is digital asymmetry, also what we want to look at which kind of situations this digital asymmetry generates and how to remedy to them. Because the general thinking, and it's true, it's part of how to address digital asymmetry, is that it's a problem of asymmetry of information. The consumer is less informed, and a lot of things can be solved by more information or different ways of addressing this information. But this digital asymmetry, in our view, also generates situations of aggressive practices, where the data, this data-driven economy, these data are used to precisely tackle the vulnerabilities of a particular consumer and put this consumer in a situation of very, very, very risky weaknesses. So we probably need also, we are thinking about it, to address better in our legal framework what are these aggressive practices related, generated in the digital markets. So two ideas of what we are exploring in this digital fairness, what we need to think in terms of possible, if the law is enough, and what might have to be modified specifically done. This is the reflection stage. Looking at all this in parallel, we have to take into account the new pieces of legislation that have been just adopted by the European Commission, if they have been mentioned today also, Digital Service Act, Digital Markets Act, what is in the pipeline right now, the Artificial Intelligence Act, the Data Act, other more specific things, how these type of issues are addressed, is that enough, and at the same time also looking at what happens in the enforcement by authorities, by different type of authorities, how these rules that I have just mentioned that can be interpreted in a broader way to address digital asymmetries, to address a specific practice, how they are used, are they enough or not? So definitely short answer, long answer, yes. We need to tackle, we need to take into account the concept of digital asymmetry, and we are working on it. Thank you very much.
Thank you. If we pass along, I'll come to the lawmakers first. So René, your thoughts on digital asymmetry or structural asymmetry, which I'm sort of paraphrasing in my head as companies having much more power than consumers in the digital sphere. How do we address that?
I think you're precisely mentioning the right word that is to be addressed here. It is indeed about power. And that brings me nevertheless back to the keynote that we have just heard. Because in my understanding, it is the whole purpose of competition law to address power. Or as Louis Brandeis, former Supreme Court judge of the United States in the 1930s, called it the curse of bigness. So the very fact that we have big players on the market has implications for the market structure, under which everybody who is not as big suffers. The environment, consumers, citizens, small and medium-sized enterprises, etc. It is therefore not sufficient for competition law to simply look at the price mechanism, what they then call the consumer welfare standard. That sounds like consumer, but actually the consumer is not very much found back in this standard. And by that, in my eyes, failing the job. And as competition law has failed the job, we had to come up with regulation, the DMA and the DSA as proper examples. But when we look at the DMA, In my eyes, the mistake of the last 20 years in consumer protection or user protection regulation is just repeated. The paradigm we were building on all legislation is that the power is not with companies, but with the consumer, and with the will of the consumer, and by giving consent or not consent. So we just throw more and more information on the consumer, starting with probably necessary bits in the 90s, and getting more and more and more and more information over every kind of revision of every kind of consumer protection law. Thinking that if the consumer is just better and better and better informed, he or she will finally make use of his or her powers of will in order to refuse consent when practices are not the right ones. Yet we see after 20 years that is obviously not the case, because we need again another round of legislation to protect consumers. And we have seen this, Vice President Vestager mentioned it with the reference to the GDPR. I mean, it's absolutely not a surprise that GDPR was a failure in its application. Because again, it was putting all on the end user, giving consent to each processing purpose whenever data is processed by big companies. But then companies are making a huge cloud of dark patterns around it. Just give your consent, otherwise world will go down, or whatever is going to happen. I mean, you all know it when going through the internet, the cookie hell or all those banners that are flagging up. So this is already misleading consumers. But at the same time, especially when we're looking at digital markets, we are already speaking of essential facilities. Even if you are a consumer who is well informed, who knows that WhatsApp is a huge problem and you're selling your soul once you install it, you nevertheless do it if you are a parent. I'm now a parent of 2 sons of 4 and 5, and there is then the kindergarten or the school app of the parents, which is of course on WhatsApp, and so you're forced to go there because there are no interoperability standards. Hence, you sell your soul although you don't want to. And that shows that the entire market structure is completely distorted. It simply doesn't work, which would actually be the job of competition law, and not of consumers refusing their consent to do the job. So in that sense, the DMA goes a step further because it wants to address failures in the market structure. It also repeats the consent issue because it's also relating to consent when it comes to certain business practices, but it also goes beyond. And in my eyes, that shows where our next round of legislation has going towards. So I do believe the DMA is here really a game changer, because it shifts us back into the times where it is not the power, the assumed power with the informed consumer, but it is simply the task of the public, of the state, to regulate markets, to regulate products, to just not let certain products and services enter the market so that the consumers are not exposed to it. And by that, taking a part of recalibrating those asymmetries. Putting all the responsibility on the consumers is not the right approach and is, in my eyes, also not to work. Hence, when we are speaking of the vulnerable consumer, which was invented in a different context, I'm convinced that the relationship is currently the opposite. The vulnerable consumer is the average consumer. So let's get rid of this distinction, and let's also adjust our legislative practices towards this and have a change in paradigm when it comes to consumer protection law, in particular in the digital, but not only. Because as you rightly mentioned, those power asymmetries are not only an issue of the digital world, but also in the non-digital world. Thanks.
Léon, we've heard there from the lawmakers' perspectives, it's a thorny issue. Give us your thoughts on how we tackle this.
Yes, thank you first to inviting me and our association. We are representing the web shops. We are the evil ones, which are subject to this conference. Let me say something on that. First, I think we can agree, also from a business, that there is a change in, let me say, a overall vulnerability when we look to digital relations. But basically, we think that concept is not new. That there is an overall vulnerability. When I remember good, when we introduced the Unfair Contract Terms Directive, this was was, let me say, the basis of this legislation, that basically the consumer could trust on let me say, the trader having contract terms that they would be fair without reading them, but only having the possibilities to read them. And to be fair, the use of contract terms is in not reading them. Because and that brings me to the information part of our legislation we have now. The legislation is full of information. We have to provide, as an industry, we have to provide consumers, and especially as digital, we are able to provide this information. If you look at the small print on the under the pages, we give you information about the contract terms. We give you information about what we do with your data. We give you information about cookies and so on and so on. But to be fair, may I ask you, whoever reads them? Here in the public, whoever reads this information we are providing you. So I think the observation is right that providing information, like you, Florencia, also said, providing information is not a clue for protecting consumers in their relation with providers. And what we think in the industry, the basis should be trust. The basis should be trust, so that the consumer can trust the industry and can trust merchants in treating them in a fair way. So not abusing their asymmetric position, the imbalance in power which is there, so that we can provide trust to the consumer that we are working fair. But then we need to have concepts about what is fair in the digital economy. What is fair? We need guidance, and I'm in that way I'm a bit inspired by the legislation on unfair contract terms, where especially when we look to the Netherlands, for instance, where we have a annex, a list of clauses or in a broader context of concepts which are always seen as unfair. So you can dispute about it. This gives legal certainty to traders, to the industry, and also to consumers, what will be fair and not will be fair. Then we have a list of what we call gray clauses or gray behavior, which is suspected to be unfair unless the trader proves or gives evidence that in his case, in his circumstances, it isn't unfair. And then we have the general concept of fairness. So, which we see also in a broader context of consumer law. We see that judges have to judge this fairness ad officio. So the consumer doesn't need to bring up in the court case his protection arguments. The judges have to do it from their own. They have to access it from their own. And if we try to access the concept of vulnerability in that way, in that perspective, that where we have to first rely on the industry that it's capable to offer a fair treatment of consumers, but also we have to give them clues, we give them, let me say, rules, we give them examples of which behavior is seen as unfair or is seen as an abuse of this digital asymmetry. So I think we have to look to this new concept. It also makes it easier for traders because we don't need to provide this huge pile of information which nobody reads. So we can be we can be expected to trade consumers in a fair way. And if we are accused to do not, maybe we have a duty as an industry to show that in our cases we did our utmost to do it in a fair way. And maybe we have to be corrected, because we have to find a balance between what's fair and what's unfair between consumers and digital enterprises, and to be be clear, digital is not only online. Digital is everywhere. It's also in the normal shops, in the offline shops. So we have to see this concept, which I formerly had in the German-speaking countries, the Treuhand concept, where the trader is expected to act in the interest of his customer. And I think if we approach in a horizontal way this concept and try to work it out, not an individual, let me say, legislation giving consumers some power which he doesn't use and isn't able to use, but give it in a more broader sense to everybody. And then we have to leave the concept that the individual consumer is able to protect himself. So we have to have, let me say, a general concept of assessment of let me say, this unfair practices or fair practices by supervision, by enforcement authorities, by consumer organizations, and everybody, politics, and everybody who is involved in, let me say, shaping this digital environment in such a way that it is fair.
It sounds rather that you're arguing for a principles-based approach rather than a rules-based approach, which doesn't necessarily always work when it comes to bad actors. So we'll come back to that. Florencia, I know you to rapidly go through your slides. So let me ask you to expand a bit more on this idea that transparency isn't the overall panacea. Léon just said, who reads all these terms and conditions? Well, apart from Finn at the Norwegian Consumer Council, I don't think anyone does. So grab the microphone.
Right. So
Is it on?
can you hear me?
Yes.
Okay, great. So yes, transparency is no panacea. It sounds wonderful in theory, but it doesn't work in practice. The question is, what do we do now? Where do we go next? And the idea of transparency and disclosure is so has such a strong hold on us because it's terrific in a way. If consumers are informed, it preserves choice. It doesn't interfere with markets. It doesn't really hinder any kind of innovation. If we have a strong competition policy, it's all wonderful. So it's been very hard to let go of that idea because what's next becomes a lot harder, right? There's ex post scrutiny, and this is what my two co-reporters, Oren Bargil and Omri Ben-Shahar, and I did when we were canvassing the doctrine of the restatement of consumer contracts. We're doing, well, let's think about this, how courts are actually thinking about this issue. Yes, there's transparency and consent, which has been at the center of consumer protection, but there's also these ex post mechanisms. We have the EU has the Unfair Terms Directive, or the great, that has great terms and terms that are deemed unfair, and that's great. In the US, we do not have that. So we have different approaches. And the approaches are necessarily exposed in this way. We have unconscionability, so look at terms or practices that are unfair or that go against the reasonable expectation of consumers, which are in many ways created or generated by businesses, but also takes into account how the consumer mindset works in particular environments, and that takes architecture into account. There's deception. I'm sure we're going to have a panel with a FTC director later on who's going to probably talk about Section 5, unfair and deceptive practices. This is a wonderful tool, but enforcement, the FTC is a wonderful agency, but the tools are not enormous in terms of the overall enforcement in a wide-scale basis. So we need to deploy this in a more systematic way. And then we have interpretation terms. So using the reasonable interpretations, reasonable expectations of consumers as a lens with which to analyze the architecture and the terms that consumers are being presented to. So the answer is maybe we need to do more. Maybe what we need to do when we think of regulation, usually what happens with regulation is that once we have it, and our speaker Vice Chairman before talked about that. It's not that our regulation remains, happens and it stays there. We need to revise it and revisit it. And the way to do so is by examining the effectiveness of the regulation. We talked about the effectiveness of GDPR. So some of the work that I've been doing is focusing on the effectiveness of GDPR enforcement, or effectiveness of FTC enforcement, or the effectiveness of disclosure regulation. I think doing more empirical studies of how regulations work, but also how consumers and market actors interact with those regulations should further inform subsequent practices. So I think the fear is to create these regulations that might create lots of costs, not only on market actors, but also on consumers. I think if we have a light touch in the sense that, well, maybe we'll have this regulation for a particular amount of time and it sunsets or it gets to be revised again, maybe we'll be less fearful and we can regulate in ways that are perhaps a bit more substantive, but also have enough escape valves so that we don't get stuck with a regime that could be greatly costly and doesn't necessarily work.
Hans, I wanted to ask you to expand on the idea of harm and quantifying harm. We spoke about imbalance, we spoke about power, but surely when it comes to assessing case law and cases, we have to look at what harm may have been done to a consumer. And is undue influence as a concept meeting that level?
No. A clear no. That throws us back 100 years. Yeah? It took us roughly 50 years to get rid of negligence, intent in market behavior law. Yeah? And we should not go back. And that's why I don't like the word of manipulation. If you write down manipulation into the law, that is the guarantee for ineffectiveness, because you can never prove intent. Yeah, that's just impossible. And I think that brings me back to, I would like to put some salt here in this agreement that I feel on that asymmetry, digital asymmetry can be something. Yeah, I think the first point is information doesn't work, and that has to be accepted by the legislator. We see the contrary. Yeah, I'm sitting in an advisory board to the German Ministry of Justice, and I raised the point: how can you continue in Germany and in the EU to adopt laws on information from whom you know that they will never work? Is this not unconstitutional? I would like to see that discussed. Can you, as a legislator, go on and adopt laws which are symbolic? I think everybody agrees on this. Where are the consequences? If this is not the consequence, and that brings me to the harm perspective, yeah, I see it reversal of burden of proof. The reversal of burden of proof is a game changer. Think of product liability law. What was the clue? The clue was when the courts decided, we reverse the burden of proof. Yeah? Same in non-discrimination law. The Court of Justice decided reversal of burden of proof. And that takes away this intentional element. It takes away who has been harmed and who has to prove what kind of harm has to be presented. I am very much in favor of reversal of burden of proof. And I'm pretty sure that at some points courts will be ready to do it. Because if the legislator doesn't really accept that something has to change and that we cannot continue adding on information, and here I would even refer to the business side. Yeah? Business knows information is costly, consumers know it's widely useless, and the legislator goes on. Yeah? So I think there is a game changer needed here. And then the point is, if we have reversal of proof, and I would like to seize this occasion, yeah, what is the benchmark? And the benchmark cannot be, and here I disagree, these black lists or whatever. Because in the digital environment, what we have, it's not these general requirements in the law. It's the underground. It's really the technical standards, the algorithms, what's in the algorithms. That is the key. And I'm sorry, I'm a lawyer, yeah? I have to learn a lot at my age to understand what these algorithms are doing, but I think we have to. And if we just delegate it away to these standardization bodies, we are outsourcing all the relevant legal issues. We are privatizing them to particular bodies that are not equipped for this. Yeah? The commissioner mentioned the Artificial Intelligence Act. Let us not forget, these standardization bodies that are drafted, that are supposed to draft all these benchmarks, they should be able to test psychological harm. Okay, where are the psychologists in the standardization bodies? They have to assess fundamental rights. Wow. The engineers are now, the software engineers are now testing fundamental rights. Yeah? Frankly, I'm getting nervous.
Yes, I could be distracting.
Thank you, Hans. You've made all my questions completely irrelevant. Does anyone want to react or pick up on what Hans has been saying? Léon?
Maybe to react. I guess you're right that fairness is a dynamic concept that cannot be put in, let me say, in fair surroundings or brick mortar to have it as a concept. You always have to look to the developments, for instance, on the use of algorithms, on the use of data, what is fair, seen the developments in the market. So there isn't a general concept of what's a black behavior or gray behavior or fair behavior. Black behavior is a concept that's based on unfairness. But we can agree sometimes that certain behavior certainly is an abuse of this digital asymmetry, which has a potential harm to consumers. And so the benefit of those lists, of those black and gray lists, is that it gives legal certainty, that it gives, let me say, as well consumers as the industry gives us kind of legal certainty. What are the borders of what's allowed and what's not allowed, what's fair and what's not fair. And of course, if we notice that it doesn't work, we have to change this list. We have to adapt them to reality. In my view, the basic concept is fairness and not the lists. And fairness is a dynamic concept. You have to assess time by time, seen the development we've seen. I've now been 16 years in digital commerce, and it started very, let me say, with small companies, companies developing. In the beginning, we didn't use data. We use data. There are services offered by platforms and so on and so on. You have to look to the whole concept. You have to look in a holistic approach, not only on contract terms, but also on the use of AI, the use of algorithms, the architecture, like you mentioned, the relation you have with your trader. So you have to have a holistic approach to again and again and again find out again what is fair and is what not fair as a dynamic concept.
Well, Blanca, let me come to you on this digital fairness fitness test. It sort of implies a horizontal approach, but I know as well you're focusing in on specific areas like personalization practices or virtual terms or influencer marketing, that sort of thing. Where do you think the emphasis should be? I mean, should it be horizontal or should we be looking at specific problem areas?
Well, first of all, let me say, Jennifer, that we are approaching it with a very broad mind, and it is an exercise which is horizontal. We are not closing any boxes or any possibility. We have explained that the digital fairness is about our 4 main pieces of legislation because they are the ones which exist, and we need to evaluate unfair commercial practices, unfair contract terms, 3 pieces of legislation, unfair contract terms, consumer rights directive, 3 pieces of legislation basically. But that doesn't mean that, but if they are not enough, we are ready to contemplate other things. We have to check if they are taking on the words by Florencia. We have to check if they are effective, if they are really targeting well the objectives that they are pursuing, if they are efficient also in terms of cost, and if they are still relevant for the different problems and different issues that we encounter in the digital market. And when we have said, because I think, Jennifer, you are referring to this in our roadmap or a call for evidence, that we are going to look at issues such as influencers, such as dark patterns, such as personalization, it doesn't mean that we are only going to look at these issues. The such as is very important. We are going to tackle things like the burden of proof, which has been mentioned also today. We are going to tackle more horizontally is information enough in these digital markets. And very important in this exercise, it's the process of consultation. It's basically the exercise itself. It's about consultation, a broader consultation of all possible stakeholders. The call for evidence or roadmap was the first step, and we got interesting feedback confirming the issues that we want to tackle and several more. We are going to launch a public consultation before the end of the year, broader public consultation. 12 weeks to respond. We are going to conduct surveys. We have a consultant. You know that the Commission in this type of exercise usually has a consultant to make a study more in depth. And together with this consultant, we are going to conduct surveys. We are going to conduct sweeps. We are going to conduct more targeted and specific interviews, apart from, of course, the discussions at events like this, which are very, very relevant, and many more to come. So it is horizontal, it is broad, all the possible issues that arise, possible concerns, the digital markets are there to be assessed in contrast with our laws, with our rules, if they are fit for the purpose or they are not.
Thank you. And I'm going to give you a rather broad question, the opportunity to respond to anything you've heard so far, but also to comment on whether you think the consumer is front and centre enough with regard to recent DSA, DMA. Again? Is the consumer front and centre enough in context of the DSA or the DMA?
It again depends on which paradigm you're starting off. So I completely share the critique put forward by Hans Micklitz. But he's also right by saying it's good that you share it, but where is the change in legislative activity? Now, I could then personally say, well, I'm only here since February, so there was not much possibility for me to change, and before that I was an academic. So in that sense, that's one way to react to it. But the second one is, and that goes a bit deeper. Now, I think that the DMA and the DSA did what they could do, given that, with all due respect, the Commission was not very ambitious in its proposals, and we as Parliament had to push ambition up. I will just refer to the discussions all around targeted advertising, which is a core problem here, and where the positions, not only within Parliament, between the left and the right side of the House, but also between Parliament and the Council, were so, let's call it, diverse, that we ended up in what is always happening when the debates are too diverse, copy-pasting exercise of what had already found a political compromise in the past. So taking out the GDPR provisions, copy-pasting them in parts in the DMA and parts in the DSA, making some nice references in the recitals, job done. Only it was not done, because it's a perpetuation of old concepts. And that is why this information conviction survives all the time. Because whenever there is political conflict, we lack, be it procedures, be it the power, I'm not yet there in my own analysis, to overturn certain concepts, because it is very comfortable in the political discussion situation to return to old concepts where we already have found compromises in the past. To overcome this, I believe, a core role nevertheless comes in our institutional setup to the Commission, because they have the monopoly of proposing legislation. So if the Commission comes up with a new round of consumer protection rules in which information is out in order to make it easier for businesses to do their job, and in return reversal of burden of proof is in, fantastic. Then we get a total different debate in Parliament. If, however, the Commission comes already with the old style kind of legislation in the Parliament, then the old debates are repeating. The business side wants to get out the information, and we want to strengthen the consumer protection rules, and we all end up by increasing information, because that's the compromise, and it's honestly nonsense. It's honestly nonsense. But I have asked Commissioner Reinders, when we had the structured dialogue in IMCO committee, about the reversal of burden of proof. Because I'm also trained civil lawyer, so I'm completely with Hans Micklitz that this is the key. Liability is the key to force businesses to act, not competition or not regulation, it's liability, and in liability the issue is proof, and therefore reversal of burden of proof, or at least the assumption, a legal assumption for a violation is the way out. And Reinders looked at me by saying, I know what you mean, but it's not going to work, because either we lack the union competence for it, saying that 352 would not work, I disagree, or we lack the political power to get a unanimity in the council, and I think here lies the truth in it. That makes it that I'm personally committed to this approach. Get rid of the information and strengthen the reversal of burden of proof. We have in the due diligence directive now the occasion to go for it. In product safety, we tried it, it didn't work. We are getting now the revisions of AI liability and product liability, where precisely this is going to play a core role. But in order to get out of this, first of all, we have to see what the Commission brings as a proposal. If it is repeating the old paradigms, then we need business NGOs, let's call it like this, making clear to their friends from the EPP and Renew, okay, we want to get rid of information, then they will all clap, but at the same time you have to accept that consumers need to get something in return. And for the other side, it's part of it by saying, let's get rid of the information paradigm, but we get something in return, which might be in the area of proof. So, and that is a common and joint effort. I personally would commit myself to table amendments in that, of that kind. Whether it finds a majority is a different question. That brings me to the second point that Hans Micklitz was making on the delegation of checking on algorithms to standardization bodies. Because this is the second point. My old expertise was financial market regulation. And here in 2009, as a result of the financial market crisis, we were able to establish union agencies with very strict powers to intervene into markets. ESMA giving the powers to forbid certain financial products. Yet, when we are looking at product safety, and by that understanding AI and algorithms as products in this very logic, we return to the old product safety logic, where things are given to standardization bodies. And that is wrong. Let's learn the lessons that we had made in the meantime in financial market regulation and establish a governance mechanisms for checking on AI precisely as we have it for financial markets. At least that I was already able to table in IMCO. Let's see whether it will find its way back in the Parliament's position on the AI Act. But these are precisely the consequences that we have to draw from our observations. And with all due respect, it goes beyond looking into something or consulting. It requires to act. And this is now the moment to act, since if we want to get something done before the European elections, it has to be started now. So my hope is really the next round of product liability and AI liability regulation to get us a step further in this shift of paradigm.
We are always living to those election timetables in Brussels.
Not only in Brussels, in all capitals.
I know we're more or less done, but we started a little bit late, so I'm going to let us have a few questions. Any questions to our panel from the audience? Let's see your hands. Christine, and yes, a couple of...
Thank you very much. Yes, so I think I completely agree what's been said about the information paradigm, and we also have come to the realization that providing information is not going to be the panacea, as it was called, for consumer protection. In the discussion now, it seems that the discussion shifts from, or actually creeps towards the solution that we need a reversal of the burden of proof, which I think in some reasons may be very well justified. I also wonder if we need to diversify the discussion a bit here and say, right, maybe in some occasions we may want to look at standardization, which in actually some cases and some pieces of research seems to work in terms of providing better information to consumers. That would be, let's say, a lighter form of regulation. I think I would also want to look at a more stringent form. I think sometimes the conclusion will be that if you start looking at those practices and the effects of information, and you come to the realization that you can't change the behavior, so you can't change the consumer behavior, and the practice is very harmful, that we should actually also just fairly and squarely discuss banning some of these practices. So this is sort of trying to maybe diversify the policy response to these issues, and I was wondering if any of you has any remarks or ideas or responses around this. Thank you.
Trace, is that to everyone on the panel or anyone specifically? Oh, yes.
I have some thoughts on that. So I agree, and I think the key to that is to study it. It's been said before, we need to look into practices, harmful practices. So for example, there's some types of standardized disclosures that may work. So restaurant grades or some health notes, so things that are very specific, some just-in-time disclosures. Others don't work at all. Or there's some practices that are so harmful, like post-transaction marketing, which is a practice where after purchasing a product, the main retailer had an agreement with some third party who would then trick the consumer into signing up to some kind of club or membership rewards club whose rewards were never used. And that practice was banned in an act after studying it and realizing that nobody took advantage of those rewards. So I think by having these specific tailored studies, we can have more, as you say, more kind of fine-tuned or granular types of regulation. It's more work, but it's certainly worthwhile.
Anyone else want to tackle that? Yes, Blanca. Thank you.
Well, the same here. I think there's no one-size-fits-all, and I cannot anticipate the results of this digital fairness. But yes, we might very well be in the situation where we will have to add some practices to our blacklist, the blacklist of unfair commercial practices, things that have to be banned. On other cases, we'll have to continue to tackle these issues through information, I'm sorry to say, because it will be the only solution. I said that we are going to look at the burden of the proof. We are going to look at it, and we are going to assess it. I cannot anticipate the results. I understand, as Commissioner Renders very rightly responded, because it's a very risky exercise. It might be that in some situations it has to be reversed, but in others it will be counterproductive. So it's, I think the study that we are doing, this evaluation, is absolutely necessary in this respect, to assess all the possible issues, all the possible problems, and try to find a better solution how to address them.
Yeah, René?
Only one short remark, because the question seems to insinuate as if standardization and the reversal of burden of proof would be alternatives. There are different stages of the process. So if we have good standardization, then ultimately we don't need reversal of burden of proof because all is good for the consumer. So if we have good standardization, then the letter is not needed. But where the reversal of the burden of proof, at least in my understanding, comes in is that we currently lack the proper enforcement tools in order to protect consumers as being the weaker party in here. So I'm with you that standardization can do the job. At the same time, we have to look at the governance structure, how standards are developed, and which incentives and interests are here at stake. And currently, the delegation of standard making to private bodies at least raises some critical questions. Once again, I'm coming from financial market regulation, and credit rating agencies were bringing us into this mess. So I'm for standardization, but I'm not a big fan of the current governance model. And at the same time, standardization is an earlier step and doesn't exclude that ultimately, in order to close the enforcement gap, we need a reversal of burden of proof.
Augustine.
Thank you. Actually, my question was exactly about that, the relationship between the law and the standards. And you used the example of the ESAs, the European Supervisory Authorities, which, of course, it has been a revolution in terms of supervision and enforcement. But of course, it's the whole question about who developed these standards, who developed these guidelines, and with which input. And something that we have seen in financial markets is that the lobbying of the industry at the level of the ESAs is massive. And the type of discussion that we have at ESA level is completely different to the type of discussion that we have in Brussels with the policymakers. So really interested about this relationship between the standards and the law, and also how the courts will react to those standards. Will the standards then become the law? Will the code then become the law? So I would appreciate any reflections on that. Thank you.
I think that's almost a rhetorical question. Do we have any other questions in the room? Anybody else? Yes, down here and just here. You're first, I think.
Okay, thank you. I'm from the Danish Consumer Council, and I want to ask, I agree totally on the information overload problem, but also we have a huge problem concerning consent and how to get a consent online. So I would just like to hear any remarks on that challenge. Thanks.
Okay. Blanca, did you want to? You're nodding.
I'm happy to take the floor. Maybe others have more interesting things to say, because I'm repeating again and again the same message, that it's the kind of thing to which we are going to look, consent, but also that the subscriptions, how to withdraw from subscriptions, that it's right now it's much easier to give the consent than to withdraw the consent. Some member states are already tackling these issues. Do we need a button to withdraw from a subscription, from having given the consent? So it's the part of the reflection that we are conducting.
I do believe that DMA and DSA have addressed the issue, which goes under the title of dark patterns. The DMA, with only looking at it in case the DMA obligations are of course undermined, but the DSA going here further. So I do believe, let's see how the DSA plays out in reality here. But that brings me ultimately back to the issue of enforcement, because already under GDPR you could do a lot against what is happening to misguide and mislead consent giving. And it happened only in January this year that the French authorities issued a fine against Google for the use of for the cookie hell, and that shows 5 years after the entry into force of GDPR, we have the first tough enforcement decision that is coming in here. So now we have finished the fights on DMA and DSA, and it was rightly a question that was also given to to Vice President Vestager. DMA enforcement and the DSA enforcement then at the level of national authorities is here key. We have already beautiful rules with regard to that in the past, but we lacked enforcement. And that's where we have to put the pressure, and continuous pressure.
Thank you. Hans.
Thank you for, I think you put your finger on a very difficult point. I would throw into the debate the idea of a kind of post-consent management, which comes closer to reality. What does that mean? So Gerald Spindler, who is a specialist in the field, he proposed that each and every customer should have a right to know what kind of profile the company has built on the data that he or she has made available. Yeah? And I think that would be something in the direction where it should go. I promise to be short.
Yes, a final question.
Can you hear me?
Yes.
Okay, thank you. I'm not a lawyer, I declare that. I don't know, and I can't do specific legal questions, but I want to see the whole thing from another aspect. I can't but remember T.S. Eliot's poem, "Where is wisdom, we lost for knowledge. Where is knowledge, we lost for information." The thing is information. The biggest challenge for me is how we can go back to wisdom, how we can teach people to find their way back, to have a holistic approach of the thing. Because everything in our life today is an asymmetry, everything. Our lives have been very complicated. We need a manual for the simplest act of our everyday life, how to buy food or whatever. So I think the best way, the most safe way for people to be not victims is to try, along with legal issues and legal arms, to make them find their stigma and be able to be critical. This is the most difficult thing, and this is what we need in democracy. Because democracy without knowledge and critical minds, it's not able. So this is the biggest challenge. I don't know, this needs a synergy, and it's a very, very, very big effort to try to combine all our efforts in legal or social or whatever, in educational systems, to make people think holistically. Thank you.
Yep. I mean, I think most businesses take a holistic approach to making profit, which they would say they use knowledge for.
Yeah, that is an excellent point. And it's true that we do need information. And if we think about, you talk about the holistic approach, when you think about going to a grocery store and buying a tomato, you know, there's no standard terms attached or anything. When you buy the tomato on Amazon or some other retailer, there's a string of terms that go with it. So the problem is not information, but it's hidden information. And also, then this has to do, you said, you know, a lawyer, it has to do with extra legal terms or trust, as we were saying. Right now, most of our online transactions are governed by contract, and it's everywhere. Even things that usually they're very simple, you know, contractual transactions like buying a tomato doesn't really come with terms and conditions. I think the problem is not one of information, but excessive information and hidden information. And one perhaps where contract is really, I mean, the irony is that contract is based on this notion of mutual assent, this meeting of the minds. What happens in our online world has nothing to do with the meeting of the minds. And I think this is a consequence of, well, first contract was what took over in terms of, well, there's not much in terms of regulation, so how are we going to govern all of these data transactions and what happens when consumers and firms enter into deals with one another? It's really contracts. So fine print took over much of this legal vacuum, and later on, when we start regulating, it was based on what was already there. Now, that's not to say that we don't benefit from wonderful things that technology and the digital world has brought, but in a way, it has perpetuated this myth of informed consent, and that is the problem, in my view.
Well, we have run over time because I think it was an absolutely fascinating panel, and we're not going to solve the issues in an hour and 10 minutes. But a big round of applause, please. Thank you. to all our panelists.